Hello, everyone. This is Gilbert Jalon. I'm talking to you here from Private Corporate Counsel, downtown Orlando. This is Tufts on Tax, where all your tax questions and issues are answered right here with Mr. T. Scott Tufts. You can call him at 877-647-7887, or you can call the same number, which is 407-647-7887. You can email him at stufts@pcc.law. That's STUFTS at pcc.law, or you can visit the website at privatecorporatecounsel.com. Hello, Scott. How are you?
Hey, good to be with you.
Good to be with you, too. Now, today, again, we talked about Loper Bright in the past two episodes. We were following up, and now we're talking about the tax case after Loper Bright.
Yeah, so we've got a new case, and it's the Shands v. Commissioner case out of the District of Columbia Circuit, which is the Federal Court of Appeals that sits over the tax court on many of these decisions.
And if you can explain to us, what does that mean?
DC Circuit Court of Appeals would just be your court below the Supreme Court. So if you appeal a tax court matter, us in this kind of world know that you then go to the next court up. It's not always the DC Circuit, but in the case of whistleblower cases, that's where you'll go. And you then, if you can go from an appeal from there to the Supreme Court. And of course, in Loper Bright, while it's not a tax case, the Loper Bright decision reversed and vacated the decisions below. So you have I think there were two different cases actually in Loper Bright. But another case impacted by Loper Bright is Lissick v. Commissioner. It's a whistleblower case, and our audience will know about Lissick if they have been following the whistleblower cases. Whistleblower cases are Section 7623 of the Code, and whistleblowers can, if they qualify and get into a situation where they appeal the rights, they can go into the tax court. So this is kind of how the whistleblower statute plays out in the courts. So Lissick is a case that went up in the DC Circuit, and its decision was vacated by the Supreme Court as well. So when we talk about Loper Bright being a fishing case, right, and the agency that dealt with fishing, then we started to look at Loper Bright and its impact on the tax cases, right, and that's the IRS. And now we go even more into a specific area of the IRS, which is the whistleblower statute. And the question now that folks are looking at in the whistleblower community is what impact, if any, will and of course there'll be an impact, but what impact does the Loper Bright decision and Lissick or otherwise have on whistleblower cases?
Right. So who's getting affected from this case, and what's going on with this case? Who's interested in this case?
Well, any of us tax professionals are going to be interested in Loper Bright, period.
Why is that?
Because Loper Bright's, let's go back. Supreme Court essentially it did overrule the Chevron doctrine. The Chevron case being an older case, and essentially it is overruled by Loper Bright. And what that says is if a statute's ambiguous or not clear, or silent, there used to be a concept called Chevron, a Supreme Court case that says you give deference and a two-step approach to the analysis. And if you determine that the statute hasn't been spoken to by Congress, you then give this deference to the agency, and in the case of Chevron, to the IRS, with respect to the interpretation of the tax regulations or rules and whatnot. And the Supreme Court has come in with Loper Bright and said that standard, that approach is not going to work. We revert back to the more comfortable area of the APA, the Administrative Procedures Act.
And how does that affect the public? Like if people are listening to your video, listening to your podcast, how is that impacting them, and what's their interest into that, and how is it going to change
so
it?
the public will get this kind of as collateral impact. And what I mean by that is if they have a tax case and they're looking at a tax case, in other words, they're going to fight the IRS, let's say, in a interpretation of a case.
Yeah.
and you're looking at some tax statute. There's a lot. The laws are extensive. So this is, the impact of the public and in the tax world is going to be, you have some tax dispute, and you've got a statute you're looking at, and you've got an interpretation at play, and you're battling with the IRS and the court, and you're before a court, and the court's trying to determine, what do we do when you're up against the IRS? What kind of deference is given? Well, no deference, but now what? Now what do we do with the regulations that they've issued or the interpretation that the IRS is giving? What about presumptions? This is an important part of this. And that's kind of where we go. So the whistleblower statute, if we get back to that, we've got the Shands case out of the D.C. Circuit, Gilbert.
Mm-hmm.
And so what's going on here is you have a whistleblower. Whistleblowers are under Section 7623 of the code. And keeping it simple here, the federal government in the Shands case, it's discussed, launched a criminal investigation of a tax evasion scheme in which Swiss bankers and a Swiss bank hid the assets of certain U.S. taxpayers in undisclosed offshore accounts. Got it? So the question became, Mr. Shands was a cooperator in the investigation. Got it? Mm-hmm. And he then gets immunity from prosecution and a whistleblower award of over $8.5 million in exchange for his assistance.
Wow.
All right? But he wants more.
More than that.
More than that.
For whistleblowing.
Yes, because why? Why did he want more?
Why is that? Maybe I need to change my career.
Well, this is no picnic. You're a whistleblower, it ain't no picnic, okay? Because there's, as Senator Grassley said, there's skunks at a picnic, and that's kind of how whistleblowers feel. They're isolated. It's not for everyone. You got to be up to the task, and you got to get good advice.
So they will rip you apart.
Well, it's just the nature of the beast. If you start going down this road,
if you make that decision.
Well, I mean, just your kids on the playground, and nobody likes a snitch or this kind of thing. But the reality is, it's a service. It's a incredible challenge. It is to do the right thing, for example. And you've got to be protected. And our laws protect people like this. Our policy is we want whistleblowers to be protected. The ones that are doing the right thing, there are laws across the board, not just tax laws, but there are laws across the board, federal and state, that are trying to reach out and have the whistleblowers essentially help our government in the pursuit of violators of the law and whatnot.
But not anyone can do that. Like it has to be something legit that he's presenting and talking about. Not come up with something.
Yeah,
and
no.
They have to have proofs in it.
No, this is not for the faint of heart. This isn't for the, you can get yourself in a world of hurt if you are coming with stuff that doesn't check out, these kinds of things. You don't want to be discredited. You don't even want to get down this road if you haven't got a case of substance and a presentation.
Absolutely.
And so this is why we use terms like distinct knowledge, personal knowledge. We use things like, what's your DK? What's your PK? Personal knowledge. What's your distinct knowledge? What do you have to bring? And does it have substance to it? And then even when you do that, you might have all that, but what else is it about it that creates an issue? Well, one of the issues is, are you up to it? It's a stressful thing. So it's not for everybody. But here's the thing with Shands. He claimed he was entitled to an additional award because the information he provided, he alleges, led to the collection of over $2.3 billion by the IRS in something that they call the voluntary disclosure program. Okay?
Oh, wow.
And so he claims that he played a part in that. So that's what he wanted when we say more. Okay? Now,
how many billions? Sorry, again?
Let's look at the numbers again. $2.3 billion through the IRS's program of the voluntary disclosure program. He believed he should get an additional award from what he originally got. All right? Now, let's kind of get, to the end here, right? Because we want to know what happened to Shands and why we're talking about it. And what we're focused on here is that, again, the 7623 statute, Gilbert, is you get a entitlement to an award if you meet its criteria. And what that criteria is, if you give information or you provide information to the IRS and they proceed with an action, either administrative or judicial, against the taxpayer based on your information. Got it? If that happens, then an award is required under the statute, right? And what they look at is if the information results in the collection of tax proceeds in a separate but related action against a person who was not identified. So think about it. You identify taxpayer 1, but what happens if it has a snowballing effect, a collateral effect, and picks up a related action? How does the IRS interpret that?
Explain
what are the regulations?
Snowballing effect.
So you say so-and-so is not properly reporting their taxes, and there's tax, and the IRS acts on that information. It's
and they find out more,
and they get that taxpayer, but they also get 10 other taxpayers because of the information you give. Should you get a claim against all 10, or should it be limited to 1?
So he's saying him giving this info helped other things, so he's entitled to get more.
He believes that snowballed, or that there's the connection. See that?
Wow.
And so the IRS is...
I see the point.
And so the IRS says, and remember, this is the government paying an award. So it's taxpayer collected money, sort of, kind of, right? So the question becomes, does the money, is there a sense of needing as a policy, right? The regulations talking about how are we going to interpret these terms?
And do they draw the line?
Exactly. Or how do they draw the line?
How they draw the line.
And what does the regulation say? So Loper Bright comes back into play and says, who drafted the regulations? Did the IRS do this with some guidance from the Congress, or did they just kind of draw some lines that someone says, I think that line's way too tight. That line doesn't meet with the statute, right? Because if the statute says X, is it clear? And if it's clear, then can the regulations pull back on that, right?
Yeah.
So our audience has got to start thinking like that. So you asked me what impact it has. I think all of us in the tax community are asking this kind of philosophical question almost, and that is, what impact does the overruling of Chevron do when you have regulations that have been put forth and the IRS has interpreted those, and these regulations are out there? What do you do when that interpretation, you want to challenge it, right? And so,
would that affect the pricing that the consumers?
I don't know.
Reaches the consumers.
Well, I don't know about pricing, but what I would say is it's certainly impacted the way that we're looking at it, because we have to go back now and moving forward, looking at the regulations. Are they being too tightly construed, or are they being too, what I mean? And so we're looking at that, and then we're looking at presumptions, and we're looking at all kinds of things. So we basically, we have to go to work. Now, remember what Loper Bright tells us. Let's go back to that one last time. And this came up in Shands. You got the statute you got to go to first. And you start with that. What does it say? Because that's kind of critical now, because what Loper Bright says is the statute and the judges exercising independent fact-finding, exercising kind of the judicial role, is emphasized in the APA. Okay? So you're looking for what the APA says is a series of either an unlawful decision, a abuse of discretion, capricious. So this standard that they use and have used for a long time when reviewing a statute, right, is the first step. Then you're going into the issue of what do the regulations say and how do they do in interpreting the statute. Judges have to make that final call. Here comes the IRS with their expertise, right? And now what do we do? there's expertise that the court considers, but it can't be this kind of overriding deference that trumps the responsibility of the judge to do what they want the judges to do under the APA. That's kind of the general philosophy. But again, we're waiting for the guidance. So Shands is the first case. So let's wrap up with what Shands says. And
this case dragged 3 episodes with us today.
Well, Loper Bright has got our attention, but
Yes.
Shands is kind of the first one out of the blocks, or maybe one of the first ones where I've picked up that in the whistleblower statute. So that's our statute they're looking at. They're looking at the regulations, and what they make clear is that they're going to interpret what the statute means by proceeding with an administrative action that was based on the information the whistleblower brought to the IRS's attention, right? And so they're taking a look at that, and they're looking at LISIC, which is out there, and the DC Circuit's going to take a look at. And it says that the regulations, right, if they're not questioned, right, they have to be questioned in order to be interpreted in the case. All right? So Shands basically loses at the DC Circuit, and this is kind of important because the basic interpretation of the case is that the OVDI program, right, does not fall under the regulatory definition of administrative action or judicial action, and thus can't provide jurisdiction. So they come back all the way around and challenge the overall jurisdiction with the Shands case, and that's kind of important because jurisdictional is the primary reason to look at the cases. So what we know is, bottom line is that everyone has to look at the terms of the statute, the whistleblower statute in particular, and know that this Shands case is out there dealing with the interpretation of these key words of the statute.
Okay, well, you heard him, folks. You can call Mr. T. Scott Tufts at 877-647-7887 if you want to find out more, or you want to call him for any cases that you're having. You can also email him at stufts@pcc.law or stufts@pcc.law. You can visit the website at privatecorporatecounsel.com. Thank you, and till next episode. Thank you.